Vital, unit 1033 given. 214 over John.
Take a seat. Sheriff's office, let me see your hands! Let me see your hands! Lay down! Lay down! Spread out on the floor! Spread out on the floor!
Pull the trigger! Pull the trigger!
Stand up, come to me now.
On New Year's Eve 2025, a Florida sheriff's deputy initiated a traffic stop for an obstructed license plate, a clear violation of Florida statute, section 306
Okay, turn around, put your hands behind your back. 214 flagger! 214 flagger, I got one running.
Vital, unit 1033 given. 214 over John.
That's the 214, the teenager just took off in the white truck.
Who's got my truck?
Give me your hands. Possible kidnapping charges.
You got me.
Put your hands behind your
You got
fucking
me.
back
I
then.
can't. You got me.
Juvenile's
You got
Bishop.
me. I will
Dwayne
cooperate. I will
Juvenile
cooperate.
took the truck as Dwayne
I can't.
Bishop.
Behind your back.
71410.
I can't do that with this.
71410.
Less 100 in the garden light. It's one and seven. Vehicles all over the road. Okay. Vehicles taking off the road. 75 miles an hour. Signal 4, signal 4, signal 4.
You going? Take a seat. Vehicle's upside down on the wood line. Sheriff's office, let me see your hands! Let me see your hands! Lay down! Spread out on the floor! Spread out on the floor! Who else is in the car? Who else is in the car?
Pull the trigger! Pull the trigger!
Stand up, come to me now. Turn around.
Yo, you put me in here.
Turn around!
Put it down. Get down on your face.
Get on
your face. Down on your face.
Yeah, go.
Get on your face.
Get on your face, do it now.
Behind your back. Do not move. Do not reach. Do not move. Go outside the car.
Who else is in the car?
Nobody.
Alright, walk up. 2014.
Get up. Are you good? Alright. I just want to make sure you're good. That's my biggest concern.
I need to go to the hospital.
Is there anybody in the car?
No, sir.
Sir, put your hand on the
I got
ground.
cause.
They told me to give you. You got my hand.
Yes, I got your hand because
He
you grabbed
said
my f***ing gun.
No, I did not. I felt
DOT.
All right.
Southbound. Southbound towards Royal Palms.
All right, you got me.
Ready?
Yeah.
Give your fucking. Don't do anything stupid.
I'm not. I'm not. Who's got my truck? Who's the truck got my truck?
Good.
Can y'all help
Roll
me?
over.
215 Oscar. Can we get up? I got a kiss. I got to really kiss.
Hey, aggravated assault on LEO.
Can we
You
get
grabbed
up?
my f***ing gun.
Okay.
We got ag assault on Elio.
The guy that's driving
with
the
the
truck.
Who
southbound.
took off with my truck? Who the fuck took
This
off
can be
with my
Dwayne.
truck?
Roll over.
Whoever was in your fucking car, you fucking retard.
I'm trying to get up.
Sit up.
Okay, I am. I am not
Stop.
fighting up. I'm not fighting up. Help me up. Help me up. Help me up. Let's try we get in.
Let's examine the constitutional framework. Under Wern versus United States, decided by the Supreme Court in 1996, any observed traffic violation provides constitutionally sufficient probable cause for a stop, regardless of the officer's underlying motivation. The Fourth Amendment permits this stop without additional justification. The obstructed plate alone closes the constitutional question at the point of initiation. Upon observing two juveniles in the back seat, the deputy began brief questioning. The Supreme Court in Maryland versus Wilson, 1997, extended Pennsylvania versus Mims to passengers, establishing that officers may order passengers out of a vehicle during any lawful traffic stop without additional justification. Questioning those passengers is equally permissible. One juvenile was noted as hesitant, reluctant to provide information, and displaying inconsistent statements. Hesitancy alone is not criminal. However, Terry versus Ohio, 1968, permits brief investigative detention when officers can articulate specific, objective facts, giving rise to reasonable suspicion. Inconsistent statements and evasive demeanor, combined with the circumstances of the stop, satisfy that threshold. Critically, no Miranda warnings were required at this stage. Berkemer versus McCarty, 1984, holds that routine traffic stops do not constitute custody. For Miranda purposes, any voluntary statements made during the roadside questioning are therefore admissible. Miranda attaches only upon formal arrest combined with interrogation. Neither condition was fully met during the questioning phase. The separation of the three parties for parallel questioning is a recognized investigative technique designed to surface contradictions. It does not independently elevate the detention to an arrest requiring probable cause. Following the interviews, the deputy placed the adult driver under arrest. The record supports the existence of probable cause at that point, derived from the inconsistencies identified during the questioning phase. At that moment, the 15-year-old passenger fled, entered the seat of the stopped vehicle, and drove away. That single act triggered criminal liability under two separate Florida felony statutes. Florida Statute Section 316.1935, subsection 3b, aggravated fleeing, and eluding with injury or property damage applies when a driver knowingly flees law enforcement after being ordered to stop and the flight results in injury to a person or damage to property. Maximum penalties upon conviction: 15 years in state prison, 15 years of probation, and a $10,000 fine. Mandatory driver's license revocation also applies, though at 15, Florida Statute Section 322.09 permits only a learner's permit, not independent vehicle operation. The juvenile was unlicensed by operation of law. Approximately 7.5 miles into the pursuit, the juvenile executed a deliberate vehicle maneuver against a pursuing deputy's Dodge Charger. That maneuver triggered the second and more serious charge. Florida Statute Section 784.07, subsection 2c, aggravated battery on a law enforcement officer applies when a person intentionally causes serious bodily harm to an officer or uses a deadly weapon against them while the officer is performing official duties. Florida courts have consistently held that a motor vehicle operated as an instrument of intentional collision qualifies as a deadly weapon. The juvenile's deliberate steering into the path of the pursuing officer's vehicle satisfies every element of this statute. Maximum penalties are identical: 15 years probation, $10,000 fine. The Supreme Court in Graham v. Connor, 1989, established that force must be evaluated objectively from the perspective of a reasonable officer at the moment of the decision. That standard is most commonly applied to officer conduct. Here it applies in reverse. The juvenile is the actor employing force, and his use of the vehicle as a weapon satisfies the deadly weapon element without ambiguity. Both charges are third-degree felonies. Because the suspect is 15, the case falls under Florida's juvenile justice system, governed by Chapter WWWW 985 Florida statutes. Sentencing discretion differs substantially from adult court. The juvenile court may impose probation, residential commitment, or diversion rather than state prison. However, under Section 985.556, the state may seek adult sanctions for serious felonies committed by juveniles. Given 2 felony charges, one involving a deadly weapon against law, enforcement prosecutorial discretion to seek adult transfer exists and cannot be ruled out at this stage. The adult driver was charged with obstruction without violence under Florida Statute Section 843.02. This is a first-degree misdemeanor, not a felony. Maximum: 1 year county jail, 12 months probation, $1,000 fine. A separate allegation that the driver grabbed the deputy's firearm during arrest was broadcast over radio as aggravated assault on a law enforcement officer. If substantiated, that would constitute an independent felony charge. All suspects are presumed innocent until proven guilty in a court of law. That presumption applies equally to the adult driver and to the juvenile, regardless of the severity of the alleged conduct. The initiating deputy receives a B+. The stop was legally sound, grounded in an articulable traffic violation, and executed with proper backup and officer safety awareness throughout the initial phase. Her use of the separation and parallel questioning technique was legally permissible and tactically competent. The arrest decision appears supported by the probable cause developed during that phase. The primary area of concern is the disputed firearm contact during the adult arrest. Post-incident review of control technique and weapon retention protocols is warranted regardless of whether the allegation is substantiated. The adult driver receives a C. His initial conduct was within normal bounds. However, the obstruction charge and the disputed firearm contact, if proven, reflect a failure to comply with a lawful law enforcement action. His presence and the dynamics of the stop may have contributed to the juvenile's decision to flee, though criminal responsibility for that act rests entirely with the juvenile. The 15-year-old receives a D. Operating a vehicle without a license, at high speed during a felony pursuit, deliberately colliding with a law enforcement vehicle, and exposing the public to serious risk. These are not impulsive errors in judgment. They are sequential, escalating criminal acts. Adolescent brain development and the reduced culpability recognized by the juvenile justice system provide context, not absolution. The juvenile court will weigh both. The legal exposure is real and substantial. Before closing, several lessons emerge from this incident that apply broadly to police-citizen encounters under Florida and federal law. First, a traffic stop for any observable violation is constitutionally valid. Disputing the basis of a stop on the scene has no legal effect and escalates rather than resolves the encounter. The proper remedy is in court. Second, passengers in a stopped vehicle have limited Fourth Amendment protection during a lawful stop. Maryland v. Wilson permits exit orders and brief questioning. Exercising the right to remain silent is lawful. Physically resisting is not. Third, fleeing law enforcement in a vehicle does not end legal jeopardy. It creates it. Every additional act operating without a license, causing property damage, colliding with an officer adds independent criminal liability. Fourth, using a vehicle as a weapon against law enforcement eliminates any argument that the encounter was nonviolent. Florida courts have consistently treated intentional vehicular contact as deadly force. Fifth, juvenile status is a mitigating factor in sentencing, not a shield from felony prosecution. Under Section 985.556, serious and repeat juvenile.com, offenders may be tried as adults at prosecutorial discretion. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below.